is State of Ohio versus George Saltis. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time, please let me know as I'll be keeping track of the time. The arguments are being recorded. When you present your argument, please introduce yourself. Keep your voice up and remain behind the podium. You should not use the name of children, minors, or victims during your argument. You can refer to them by initials or terms like the child. We have read your briefs and are prepared to proceed when you are.
Good morning, everyone, and good morning, Your Honors. May it please the Court. My name is Jack Corrigan. I am the attorney on behalf of appellant George Saltis. In this case, the judge so found the prosecutors unfairly chased the defense witness off the witness stand out of the courthouse. When the court herself inquired as to what the basis, we back up a minute. The prosecutor's argument in this case and in all cases is, well, the witness is going to say something that could potentially incriminate himself, and therefore, I'm only looking out for the witness's rights, which the defense attorney is not interested in protecting. Well, the prosecutor is a biased advocate too. But when the court inquired what's this newfound concern with the witness's rights, the prosecutor said, these were the prosecutor's words, not mine, based on his failure to cooperate. That doesn't sound like his constitutional rights to me. They didn't like what he was going to say, so they scared him off the stand. I hope my brief made it clear that I am not contesting the factual findings of the trial court. What I contest in the brief before you is the application of law applied to the facts that the trial judge found. That's the area when there's a disagreement in the briefs as to what the standard of review should be. Ultimately, the standard of review is de novo. I'm not disputing the trial judge's facts. I disagree perhaps with one of them, but it's irrelevant when we apply the law. What I'm disputing is questions of law, and similar to a motion to suppress, review of matters of law, state and Burnside, matters of law are reviewed by a court, an appellate court.
Can you tell us a little bit about the chronology of what happened here?
Okay, yeah. The facts basically involve the victim states that he was hit over the head with a gun. He bought a car from another person. But there was no bank, no nothing, title wasn't transferred. It's, I'll loan you the car, you pay me the money when you're through, then we'll transfer the title. Well, this victim wasn't making the payments, so the owner of the car comes over. Also coming over is my client. And according to the victim, he says he was arguing peacefully with the car owner. My client interjected, and the victim says he was very polite toward my client, and for some apparent, for no apparent reason, my client had a gun on him. He took the gun, struck him over his head. During the case, the witness of the car owner, so the person that I'm telling you was being chased off the stand by the prosecutors, he had spoken to the police that day, and he in fact left with both the gun and the holster. The
You're not saying the trial court cited the wrong law as far as these questions of how the prosecutor deals with witnesses may be taking a position. You're saying she applied the law she cited incorrectly. Is that correct?
Right, I'm agreeing with her factual finding and implicit threat was made. Perhaps she's saying they made it with good intent, navigating the murky waters with the language she used. But she still did find it as an implicit threat. And the U.S. v. Smith says, if regardless of a prosecutor's intent, if a threat is its substance over form, if it can be interpreted as a threat and what happens if it's made.
What specifically here was the threat the prosecutor said in this case?
They indicated that they would indict him for two things: tampering with evidence, which they've known about for years, and then perjury, because according
In the record, where they told him that we're going to indict you for these charges.
and I think not exactly.
Okay,
That was the implication of what was said.
Specifically, what did they say to him?
Pardon?
What did they say to this particular witness specifically?
We may have to give you your Miranda, and you're going to need an attorney.
You didn't ask for rebuttal time. Did you want any rebuttal time?
Sure, 5 minutes.
Well, right now you have about 4 minutes.
Okay. Unless the court has a question right now. Okay, thank you.
Good morning, Your Honors. Lindsay Poverty of the Lorain County Prosecutor's Office on behalf of the state. Although Saltis maintains that the prosecutor acted to intimidate a defendant with his friend, preventing him from testifying, this appeal actually raises conflicting issues. The defendant undoubtedly has a Sixth Amendment right to present witnesses for his defense, and this right may be violated if the government, whether it be through the trial court or the prosecutor, actively interferes to prevent a witness from testifying. But the defendant's right is tempered by a witness's Fifth Amendment right against self-incrimination, since the witness may validly choose not to testify if his testimony would be incriminating. And it is held in this context that the government may even have an ethical obligation to warn unrepresented witnesses of the risk of perjury charges.
What about the use of the term, which I don't see in any other case law, is you need Mirandize? Because Mirandize is Fifth Amendment warning in the context of a custodial arrest. So wouldn't that sound like he's being arrested if you use the word Miranda?
Correct. I think that was a concern of the trial court initially, that the word Miranda was used, but the issue that the trial court ultimately found was that the prosecutor in this case did not advise the defendant that he would be charged with any crime, and that he was not told that he had to get an attorney. The defendant was then appointed court-appointed counsel who was able to advise him of his rights against self-incrimination properly, and he then did invoke his right to against self-incrimination, which was proper. The issue before this court then is whether the prosecutor's cautionary advisements were appropriate to protect the witness's right to assert his Fifth Amendment privilege, or whether they were designed to interfere with Saltis' right to call him as a defense witness. And because the prosecutor merely provided the witness with a cautionary warning regarding testimony that may incriminate him should he take a stand, which then allowed him to reconsider whether to testify after consulting with appointed counsel, no constitutional violation occurred, and the trial court properly denied him his trial.
Counsel, can I ask, was the advisement if you testify differently than what you told the police, or was the advisement if you testify untruthfully? Two different types of scenarios, right? I mean, did this witness get the impression by what the prosecutor said that if he testified on the stand and testified and it was different than the statement he had earlier given the police, that he would be subject to prosecution?
I don't think that it was that he was given any impression that there would be certain criminal charges attached to his testimony.
Why is that when, as Judge Johnson indicated, he was advised that they should cover Mirandizing?
I acknowledge that the term Mirandize was probably not the best term to use, but it was with concern that he would possibly be facing self-incrimination. It was protection of the witnesses. It was actually for protection of the witnesses' rights, I think, in terms of what the prosecutor was doing. And it's important to note that this case does come before the court on the trial court's denial of a mistrial. And in that regard, the state does disagree with the standard of review proposed by the defense. It is before the court on the review of the trial court's denial of a motion for mistrial. And because the trial court found that Saltis ultimately suffered no prejudice due to the conduct of the state. And this court has acknowledged that it should afford great deference to a trial court's decision regarding motion for mistrial, and that motions for mistrial should only be granted where the ends of justice so require, and that is where a fair trial is no longer possible. And this is because the trial court is in the best position to determine whether the circumstances that have occurred will warrant a mistrial. And here the trial court went to great lengths to determine whether the competing interests of this, the Fifth Amendment versus the Sixth Amendment right to present a defense would be violated. And first, it is critical to point out that Saltis frames a single assigned error by attributing a finding to the trial court that it did not make in its decision. The trial court did not make a finding that the prosecutor's warning to the defense witness was a threat calculated to transform him into a willing defense witness who would not testify when it denied his motion. Rather, the trial court's decision to deny Saltis' motion for mistrial was made on alternative grounds.
Counsel, so it's my understanding that early on this witness was on the prosecutor's witness list, correct?
Correct.
And then he became, and he was also subpoenaed by the defense, so he was going to be a witness for the defense. At the time this advisement as to his Fifth Amendment rights was made, was he squarely a defense witness, or was he also a witness for the prosecution? What's the timing?
I believe that he was initially a state's witness, and then the advisement occurred during the meeting, and then after the advisement occurred, the defense indicated that it was going to subpoena him. So I believe that's the timing.
Okay, and the timing of the meeting was before anyone had started. The state had not started. The state had not rested.
No, it was on the morning of the trial.
Before the commencement of proceedings.
Correct.
Okay, thank you.
Correct.
Did his statement initially to the police possibly implicate him for him to that?
I believe so.
Did they give him some advisement at that time that he might be subject himself to possible incrimination by telling the police that? Did Mirandize him then when he was saying, hey, I did these things to make me tampering?
Did they Mirandize him at the time and
Right.
made the initial statement?
Is there any evidence of that?
I don't believe that there's any evidence.
So there only became concern when he testified differently than what the prosecutor.
At the time of at the meeting on the morning of
Yes,
the
I
trial.
mean, that's more now, the change his testimony from what the prosecutor was expecting and wanting, if you will, to something like that.
I believe that's accurate.
Does it make it more concerning then, that this is a threat to him, rather than just kindly advice to say, if you're committing perjury, you might need to be careful?
I still don't believe that the case law supports that this was a threat.
And you dispute the finding that our plaintiff, the defendant here says in paragraph 10 that this was a specific finding that there was.
I do dispute that. The trial court went through a number of factors that she considered in ultimately coming to her conclusion that there was no prejudice to the defendant. And
That's different than threat. I mean, the
Correct.
prosecutor found there was a threat, but then there was no prejudice. So that's
Correct.
what the trial court found this to be a threat, and
she
that's
also
understanding paragraph.
I'm sorry, in her conclusion at here, I think it was finding number 11, she ultimately found that the prosecutor navigated her deep waters and that there was no malicious action by the prosecutor, there was no, and that they had played a part, I believe, in the witness invoking, but the defendant also, the defense also never objected to the defendant invoking, and I believe that the trial court.
How would they object to anyone? Maybe the defendant, you mean the witness invoking the right.
The defense never made an objection at the time that the witness actually invoked his right to self-incrimination, and the trial court noted that in its entry, that neither party objected to the invocation of the defendant.
Does either one have the right to object? When the witness said, I'd like to take a fair plea, do you have the right?
That's a personal right, I understand that, and that's just something that the trial court did indicate in its entry. And we would distinguish the case of United States versus Smith that Saltis relies on, because I do think that the United States, the Seventh Circuit in Smith did find that that was plainly a threat, and that is why they reversed in that case. And in that case, in light of the witness's potential for self-incrimination, the prosecutor in that case told the witness to get an attorney, identified future charges with which the witness would be charged, and told him that he would be prosecuted for those charges. This case is different than Smith, because the prosecutor here did not advise as to whether the witness needed to get an attorney. She specifically advised that she could not give him that advice. She specifically told the court that she never told the witness that he would be charged with an offense. And here, the trial court relied on Shaw and said that it is proper but not mandatory that a prosecutor can't advise the potential for self-incrimination.
Ultimately, the court did appoint the witness, a lawyer, correct, who advised him about testimony. Is that right?
I'm sorry,
The court did appoint the witness, a lawyer,
after his request for a lawyer, correct.
and he did see the lawyer make a decision based on a counsel decision. Right?
Yes. So, ultimately, it was submitted that because the trial court was in the best position after making a lengthy determination that Saltis suffered no prejudice, that the trial court's decision denying the motion for mistrial
different than the witness gave to the police?
According to the police, again, I'm thinking, my cousin Vinny, I shot the clerk, and the detective, he said he shot the clerk and he denied it. So it's for the prior fact to flush out whether it's inconsistent or not. And I'd like to stress, part of this is, the state called 3 witnesses, the victim, who will be my client's nephew, and the police.
And there was no proffer of what we thought this witness was going to say on the record. Is that fair? There's an argument about it, but it was never an official proffer that defense counsel said this witness is going to say A, B, C, D, E on the record.
Right, and the record's rather shallow on what this inconsistency was, and I think the trial court even addresses that in her written. But I'd like to remind the panel is that the victim is the only person who said my client hit him in the head with a gun. He said he had a gun holstered, he took it out, he swung at me, he hit me in the back of the head. He also said, of course, when the police get there, after being struck with a gun, there was no blood, they couldn't find a bump, they couldn't find a bruise. And yet the same witness who wants us to believe he was hit in the head with a gun says, I have headaches every day. He said, I suffered a concussion. I went to the hospital, they diagnosed concussion, we have no medical records, and while he's claiming concussion, when you have retrograde amnesia, you have difficulty with the facts if you really suffer. The nephew would be the future brother-in-law of the victim. He testified that my client hit him with what must have been a gun. So he himself was unclear as to the facts of the case. So when the witness, I saw, he was hemming and hawing on whether my client hit him with a gun or whether he saw my client hit him with a gun. That's no different than the state's other witness, the nephew. I think the term Mirandizing is used because everybody knows what Miranda means, and the prosecutor was just using layperson's terms to talk to the witness used to Miranda. And the common understanding is Miranda means if I talk, I can talk myself, get myself into trouble. And again, the record can't tell us what the private conversation was, but John Cope was appointed, and he's an ex-prosecutor, he's a defense attorney, he's no dummy. The prosecutor says, you take the stand, you might be in trouble, you could get indicted. You go home, you're fine. Of course, you don't go to the mayor, and that's the witness is scared off the stand, I think. Unless you have any questions.
Thank you both for your presentations. The court will take this matter under advisement and issue a decision in due course. The clerk of courts will mail you a copy of the decision